everyone. So today we'll be discussing for the subject Constitutional Law 2, and the topic will be for special writs. So there are four special writs which the court may issue. We have Writ of Habeas Corpus, Writ of Amparo, Writ of Habeas Data, and Writ of Kalikasan. So these writs essentially involve the violation or threatened violation of certain constitutional rights. Accordingly, the Supreme Court promulgated some rules concerning the protection and enforcement of constitutional rights. So for habeas corpus, we have Rule 102 of the Rules of Court. For the writ of amparo, we have administrative matter number 07912. And writ on the habeas data, we have administrative matter number 081-16. And rules of procedure for environmental cases, Title 3, Special Civil Actions, Rule 7, Writ of Kalikasan, or Administrative Matter, number 09-6-8. So we now discuss these writs one by one. So first, we go to Writ of Habeas Corpus. So what is Writ of Habeas Corpus? It is a written order issued by a court directed to a person detaining another, commanding him to produce the body of the prisoner at the designated time and place with the day and cause of his caption and detention. So you see here in the table that what habeas corpus means is you have the body. So the privilege of writ of habeas corpus is the right to have an immediate determination of the legality of the deprivation of physical liberty. So specifically, the writ is availed to 1. Obtain immediate relief from illegal confinement, 2. Liberate those who may be imprisoned without sufficient cause, and 3. Deliver them from unlawful custody. So it seeks to inquire into all manner of involuntary restraint and to relieve a person therefrom if such restraint is illegal. In general, the purpose of the writ of habeas corpus is to determine whether or not a particular person is legally held. So it is essential a writ of inquiry, and it is granted to test the right under which a person is detained. So a prime specification of an application for a writ of habeas corpus, in fact, is an actual and effective and not merely nominal or moral illegal restraint of liberty. So the writ of habeas corpus was devised and exists as a speedy and effectual remedy to relieve persons from unlawful restraint and as the best and only sufficient defense of personal freedom. The essential object and purpose of the writ of habeas corpus is to inquire into all manner of involuntary restraint as distinguished from voluntary and to relieve a person therefrom if such restraint is illegal. So, who may suspend the privilege? So the answer is it's the president. So the first reason for the suspension of the writ is in cases of invasion or rebellion. And the second one is when public safety requires it. So habeas corpus lies only where the restraint of a person's liberty has been judicially adjudged to be illegal or unlawful. So the writ is a prerogative, and it is a writ employed to test the validity of detention. It's to secure the detainee's release. The action shall take precedence in the calendar of the court and must be acted upon immediately. So when is this writ available? First is when we have the restoration of liberty of an individual subjected to the physical restraint. Second is that it may be availed of where, as a consequence of a judicial proceeding, there has been a deprivation of a constitutional right resulting in the restraint of the person. The court has no jurisdiction to impose the sentence, or an excessive penalty has been imposed, so, since such sentence is void as to the excess. Third is we have it may be extended to cases by which rightful custody of any person is withheld from the person entitled thereto. Then also when moral restraint is exerted and that the right was accorded to a person was sentenced to a longer penalty than that was subsequently meted out to another person convicted of the same offense. And lastly, we have unlawful denial of bail. So on the other hand, when is it not available? So we have 1, when there is no deprivation of liberty or restraint, 2, when the deprivation of liberty or restraint is legal, and 3rd, to correct alleged erroneous orders of the court. So writ of habeas corpus is not intended as a substitute for the functions of the trial court. In the absence of exceptional circumstances, the orderly course of the trial should be pursued and the usual remedies exhausted before the writ may be invoked. Then fourth, we have when a person deprived of liberty through involuntary restraint or detention has been already released. So, except in the cases that if the release was conditional, such that the conditions still about to be effective, the restrictions of the constitutional rights. If then the release was not adequately proven by the respondent and grave doubts were raised. Fifth, we have when the illegal detention becomes legal by virtue of court processes. And sixth, we have when the privilege of availing of the writ is suspended by the president. So the Constitution allows the suspension of the privilege of the writ of habeas corpus in cases of invasion or rebellion, or when the public safety requires it, as we mentioned a while ago. So what may be suspended? The writ or the privilege of the writ. So the writ is never suspended. It always issues as a matter of course. What is suspended is the privilege of the writ. So for example, once the officer making the return shows to the court that the person detained is being detained for an offense covered by the suspension, the court may not inquire any further. So does the suspension of the privilege also suspend the right to bail? So the answer is no. The right to bail shall not be impaired even if the privilege of the writ of habeas corpus is suspended. This is explicitly provided for in Article 3, Section 13. So what is the procedure? So the need to comply with the writ and also the disobedience thereof constitutes contempt. So next we have writ of amparo. So what is the writ of amparo? The writ of amparo is a remedy of the writ. It is an equitable and extraordinary remedy to safeguard the right of the people to life, liberty, and security as enshrined in our 1987 Constitution. The writ of amparo serves both preventive and curative roles in addressing the problem of extralegal killings and enforced disappearances. So we'll discuss this one by one. So what more is it? It is preventive in that it breaks the expectation of impunity in the commission of these offenses, and it is curative in the sense that it facilitates the subsequent punishment of the perpetrators, as it will inevitably yield leads to subsequent investigation and action. In the long run, the goal of both the preventive and curative roles is to deter the further commission of extralegal killings and enforce disappearances. So this was cited in the case of Secretary of National Defense versus Manalo. So the remedy of the writ of amparo provides rapid judicial relief as it partakes of a summary proceeding that requires only substantial evidence to make the appropriate reliefs available to the petitioner. So it is not an action to determine the criminal guilt requiring proof beyond reasonable doubt or liability for damages requiring preponderance of evidence or administrative responsibility requiring substantial evidence that will require full and exhaustive proceedings. So the Supreme Court promulgated the Amparo Rule in light of the prevalence of extralegal killing and enforced disappearances. It was an exercise for the first time of the court's expanded power to promulgate rules to protect our people's constitutional rights, which made its maiden appearance in the 1987 Constitution in response to the Filipino experience in the martial law regime. But even now, we have a lot of extralegal killings. But anyway, what is the governing authority on the writ of amparo? As we mentioned a while ago, it's the Supreme Court rules on the writ of amparo or Administrative Matter 07-9-12. So it took effect on October 24, 2007. The rule on the writ of amparo was issued as an exercise of the Supreme Court's power to promulgate rules, as we said. And so, in light of the prevalence of these killings, it was an exercise of their power in order to protect us not to happen what happened in the martial law regime. So when is the writ of amparo available? So these are the requisites. Please take note. So the petition for writ of amparo is a remedy available to any person, number one, whose right to life, liberty, and security are violated or threatened with violation of an lawful act or omission, and such unlawful act or omission is made either by one, a public official or employee, or two, a private individual or entity acting in the interest of the government also. So particularly, it is a remedy against as we mentioned, extralegal killings and enforced disappearances. So what are extralegal killings? So extralegal killings are killings committed without due process of law. It is without legal safeguards of judicial proceedings. So the elements of this is that there must be an arrest, detention, abduction, or any form of deprivation of liberty. Second is that it be carried out by or with the authorization, support, or acquiescence of the state or political organization. Third, that it be followed by the state or political organization's refusal to acknowledge or give information on the fate of the whereabouts of the person subjected to the amparo petition. And fourth, that the intention of such refusal is to remove subject person from the protection of the law for a prolonged period of time. So we go to the other one, enforced disappearances. What is this? So it is attended by the following characteristics. First, there is an arrest, a detention, or an abduction of a person by a government official or organized groups or private individuals acting with the direct or indirect acquiescence of the government, the refusal of the state to disclose the fate or whereabouts of the person concerned, or a refusal to acknowledge the deprivation of liberty, which places such persons outside of the protection of law. What does the right to security mean? So, in the context of writ of amparo, so the right of security is an important feature of the writ of amparo. Even a person who has not been set free from captivity may apply for it if his security is threatened. So kahit na nakapakawalan ka na, you can still apply for it if nati-threaten pa yung security mo. So while the right to life under Article 3, Section 1 of the Constitution guarantees essentially the right to be alive, upon which the enjoyment of all other rights is preconditioned, the right to security of a person is a guarantee of the security quality of this life. So in the context of the writ of amparo, this right is built into the guarantees of the right to life and liberty under Section 3, Section 1, Article 3 of the Constitution, and the right to security of persons. So under Article 3, Section 2, as well as the policy of the state of guaranteeing full respect for human rights under Article 2, Section 11 of the Constitution, the right to security of a person is a guarantee of secure quality of the right to life. The life to which each person has a right, which is not life lived in fear that his person and property may be unreasonably violated by a powerful ruler. Rather, it is a life lived with the assurance that the government he established and consented to will protect the security of his person and property. So the immunity of one's person, including extensions of his persons, houses, papers, and effects against government intrusion, does not only limit the state's power over his property, but more importantly, protects the privacy and sanctity of the person himself. So the right of security includes the positive obligation of the government to ensure the observance of its duty to investigate. So the right to security covers one, the freedom from fear. It is the right, and any threats to the right of life, liberty, or security is the actionable wrong. So fear is a state of mind, diba? And a reaction, it is a threat, it is a stimulus na pag natatakot tayo, we always tend to not live a comfortable life. So second is the guarantee of bodily and psychological integrity or security. Physical injuries inflicted in the context of extralegal killings and enforced disappearances constitute more than a search or invasion of the body. Physical torture, force, and violence are severe invasion of bodily integrity when employed to vitiate the free exercise of our right to life. So for the writ of amparo to be available, is government involvement indispensable? So the answer is yes. For the writ of amparo to issue, allegation and proof that the person subjected thereof are missing are not enough. It must also be shown and proved by substantial evidence that the disappearance was, one, carried out by or with authorization, support, or acquiescence of the state or political organization, two, followed by a refusal to acknowledge the same or give information on fate or the whereabouts of the said missing persons, and three, with the intention of removing them from the protection of the law for a prolonged period of time. So does the doctrine of command responsibility apply in the amparo case? Amparo cases rather. So the answer is yes. Although originally used for ascertaining criminal complicity, the command responsibility doctrine has also been found applicable in civil cases for human rights abuses. So in amparo proceedings, the doctrine may be used to determine whether respondents are accountable for and have the duty to address the abduction of the persons involved in order for the courts to devise remedial measures to protect his rights. So when is the writ of amparo not available? So first we have when it's when what is involved is purely property or commercial rights. Second is amorphous and uncertain ground. Third is restriction of a person's right to travel as a consequence of the pendency of a criminal case filed against him. Fourth, it is not a remedy available to obtain custody over a minor child involving issues of parental authority. Although I think habeas corpus is, we read this case in persons and family relations that the foreign father used writ of habeas corpus in order to find um, the son or the daughter which the mother took away, and he doesn't know where in the Philippines the child was. So anyway, we'll discuss that further. Is hearsay evidence admissible in amparo proceedings? So the answer is yes. The Supreme Court has relaxed the application of the strict rules of evidence in amparo proceedings. It has applied the doctrine of totality of evidence. So in the amparo proceedings, can the respondents invoke the presumption of regularity in the performance of official functions since public officers sila? So the answer is no. The respondent, public official, or employee cannot invoke the presumption that official duty has been regularly performed to evade responsibility or liability. The respondents must prove that the standard of diligence, as required by applicable laws, rules, and regulations, was observed in the performance of duty. Respondent is a private, so when the respondent is a private individual or entity, what must be proved is that there was ordinary diligence. When the respondent is a public official or employee, what must be proved is that there is extraordinary diligence, taking into account their position. So what reliefs does a writ of amparo provide for the aggrieved party? So it says in section 17 on the rule on the writ of amparo that any such reliefs may be proper and appropriate. The privilege of the writ of amparo, once granted, necessarily entails the protection of the aggrieved party. Thus, since the writ was granted, there is no need to issue a temporary protection order. So we now shortly discuss the case of Secretary of Defense versus Manalo because this was already this was this was included in our Crim 1, Consti 1, and now in Consti 2. So I think it's a very important case that we have to remember. So here, the brothers Raymond and Reynaldo Manalo were farmers. They were from Bulacan and they were abducted kasi parang akala nila na parang NPA members kasi they weren't able to attend one meeting in the town and now they were suspected of being NPA members. So the Citizen Armed Forces geographical unit or the CAFGU, since they suspect that the brothers were NBA members, they abducted them, and for 18 months they restrained the liberty, they tortured, so other dehumanizing acts. But the brothers were able to escape. So 10 days after the escape, they filed a petition for prohibition, injunction, and temporary restraining order before the Supreme Court to prevent the military officers and agents from depriving them of their right to liberty and their other basic rights. So the existing petition was that, sabi ng Supreme Court, it will be treated as an amparo petition. The Supreme Court granted the writ of amparo and ordered the Court of Appeals to conduct the summary hearing and decide the petition. So the issues in that case was that whether or not statements from the victim is sufficient for amparo petitions, and second is whether or not actual deprivation of liberty is necessary to invoke the right to security of a person. So in the first issue, the answer is yes. Much of the information and evidence of the ordeal will come from the victims rather themselves, and the veracity of their account will depend on the credibility and candidness in their written and oral statements. Their statements can be corroborated by any other evidence, such as physical evidence left by the torture they suffered or landmarks which they can identify in the places where they were detained. So, in the second issue naman, kung kailangan ba ng deprivation of liberty in order to ask for the writ of amparo? So the answer is yes. Covered by the privilege of the writ, the respondents must meet the threshold requirement rather that the right to life, liberty, and security is violated or threatened with an unlawful act or omission. The right to security of a person is freedom from fear. So in the Universal Declaration of Human Rights, it states that a world in which human beings shall enjoy freedom in speech and belief and freedom from fear and want has been proclaimed as the highest aspiration of common people. Moreover, the right to security of a person is a guarantee of protection of one's rights by the government. So here, in this case, di ba nakalaya na sila, sinabi natin kanina that even if those detained has already regained their freedom, they can still apply for the writ of amparo because they feel like their life is still threatened. Because any moment that time, they can still be taken by the military officers, they can still be abducted. So it was only proper to grant the writ of amparo for the Manalo brothers. So we go now to writ of habeas data. So what is the writ of habeas data? So the writ of habeas data provides a judicial remedy to protect a person's right to control information regarding oneself, particular in instances where such information is being collected through unlawful means in order to achieve unlawful ends. So as an independent and summary remedy to protect the right to privacy. So especially the right to informational privacy, the issuance of the writ does not entail any finding of criminal, civil, or administrative culpability. So it is designed to protect the image, the honor, the information, and freedom of information of an individual, and to provide a forum to enforce one's right to the truth and informational privacy. So the writ of habeas data is a remedy available to any person whose right to privacy and life, liberty, or security is violated or threatened by an unlawful act or omission of a public official or employee, or of a private individual or entity engaged in the gathering, collecting, or storing of data or information regarding the person, family, home, and correspondence of the aggrieved party. It is an independent and summary remedy designed to protect the image, privacy, honor, information, and freedom of information of an individual, and to provide a forum to. Oh, we already said this one. So, what is the governing authority on the writ of habeas data? So, we already mentioned a while ago. I'll just reiterate that it is the Supreme Court which promulgated the writ of habeas data in Administrative Matter 08-1-16, which became effective. This was effective only on February 2, 2008. And these are the principal rules that governs the writ of habeas data. So when is the writ of habeas data available? So we have the requisites. First is the right to privacy and life, liberty, or security is violated or threatened by an unlawful act or omission. And this is quite similar to the writ of amparo. So the writ will not issue on the basis merely of an alleged unauthorized access to information about the person. So the availment of the writ requires the existence of a nexus between the right to privacy, particularly informational privacy on the one hand, and the right to life, liberty, and security on the other. Thus, the existence of a person's right to informational privacy and um, and showing that, at least by substantial evidence, of an actual or threatened violation of the victim are indispensable before the privilege of writ may be granted. So second is we have such unlawful act or omission is by the following persons engaged in gathering, collecting, or storing of data information regarding the person, family, home, and their correspondence of the aggrieved party. So we have a public official or employee and a private individual or entity. So note that, in developing the writ of habeas data, the court aimed to protect an individual's right to informational privacy, among others. So a comparative law scholar has said that it defined habeas data as a procedure designed to safeguard individual freedom from abuse in the information age. Kasi nga ngayon naman, actually there, lalo na when in the internet, you can search anyone, you can stalk anyone, and of course sometimes we feel like our right to privacy is already violated. Of course there are settings na you can, like for example in Facebook, you can set naman na umimi, ganyan ganyan, pero still sometimes there are loopholes in that. And this writ of habeas data safeguards our right to be in our own, to be informed, and to have our information never disclosed. So the writ, however, will not issue on the basis merely of an alleged unauthorized access. Yun na nga. So what is the right to informational privacy? What does this mean? So it is the right of individuals to control information about themselves, as I was saying. And such right depends on the existence of expectational privacy a person has toward particular information. So before anyone can have expectational privacy, it must be shown that the person intended such information to be private. Eh kung naka-public naman yung Facebook mo, kung naka-public naman yung Instagram, for example, so you don't really you don't really expect that these social media accounts, these information about you can be made to be private. So the writ of habeas data is not only confined to cases of extralegal killings and enforced disappearances, kasi nga we likened it to writ of amparo. Contrary to the respondent's submission, the writ of habeas data was not enacted solely for the purpose of complementing the writ of amparo. Had the framers of the rule intended to narrow the operation of the writ only to access extralegal killings or enforced disappearances, Section 2 of the rules reflecting a variance of habeas data situations would not have been made. So, nandun na tayo sa when is the writ of habeas data not available. So, while the writ of habeas data is a remedy available for the protection of one's right to privacy, the state interest, syempre, in dismantling private armed groups outweighed the alleged intrusion of a person's private life. Syempre, pag national security na yung at stake. Then we have like the writ of amparo. The writ of habeas data will not issue to protect under the context of the due process clause purely property or commercial concerns, nor when the ground invoked in support of the petitions therefore are vague or doubtful. So the employment constitutes a property right. So what reliefs does the writ of habeas data provide to the aggrieved party? If the allegations the petitioner proven through substantial evidence, then the court may grant access to the database or information, enjoy the act contained of, or in case the database or information contains erroneous data or information, order its deletion, destruction, or ratification. So the remedies include updating, rectification of the suppression or destruction of the database or information or files in possession or control of the respondents. It is not limited to cases of extralegal killings, again, and enforced disappearances. So lastly, we go to writ of kalikasan. Wait, I'll just move myself there. So we have writ of kalikasan. So what is the writ of kalikasan? It is a remedy against the enforcement of or violations of environmental and other related laws which deal with the conservation, development, preservation, protection, and utilization of the environment and natural resources. So what is the governing authority in the writ of kalikasan? It is the Rules of Procedure for Environmental Cases. It's Title 3, Special Civil Actions, Rule 7, Writ of Kalikasan, or Administrative Matter Number 09-6-8. So when is the writ of kalikasan available? So the requisites are the following. So one is whose constitutional right to a balanced and healthful ecology is violated or threatened with violation by an unlawful act or omission involving environmental damage as such magnitude as to prejudice the life, health, or property of inhabitants in 2 or more cities or provinces. 2. Such act or omission is committed by a public official or employee or private individual or entity. Note that the environmental damages must be of such magnitude as to prejudice the life, health, or property of inhabitants in 2 or more cities or provinces. So what reliefs does a writ of kalikasan provide to the aggrieved party? The reliefs that may be granted under the writ are the following. First is directing respondent to permanently cease and desist from committing acts or neglecting the performance of a duty in violation of environmental laws resulting in environmental destruction or damage. Second is directing the respondent, public official, government agency, private person, or entity to protect, preserve, rehabilitate, or restore the environment. And third, directing the respondent, public official, government agency, public employee, private person, or entity to monitor strict compliance with decision and orders of the court. Fourth, directing the respondent, public official, government agency, or private person or entity to make periodic reports on the execution of the final judgment and such other reliefs which relate to the right of the people to a balanced and healthful ecology or to the protection, preservation, rehabilitation, or restoration of the environment, except the award of damages to individual petitioners. So this ends our discussion for the 4 writs. We should remember this by heart. And thank you for listening and stay tuned to my next videos. Thank you.